Okay, you should be able to hear me now. Hello, meow away wolf. Hello, everyone. Hope y'all have a lovely day. I hope you have a lovely day as well. Bianca Johnson, you should be able to hear me now. Okay, great, great. All right. Hello, drunk cooking with bald head. I tell you, these are some interesting names that you all have come up with. I love it. I love it. Okay, home games. Glow TBH. Okay, how y'all doing? How y'all doing? All right. Well, I don't want to waste any time. I want to go ahead and jump into today's session. So, this is part two of the temporary orders hearing. And I am going to start doing these at least 2 or 3 days a week because the feedback I'm getting, they're very, very beneficial. So, we will still be doing the court cases. We just are going to make sure that we have these educational breakout sessions because they are extremely important. In my personal opinion, they're more important than the actual cases themselves because the cases show you the outcome and I give you the breakdown of why I ruled the way I did in that particular scenario. But the educational portion, what we're doing here, is very important because it walks you through how to get there. Seven, thank you. Um, my day is going great. God is good. I'm here today. I'm able to sit in front of you all with this computer screen. So I am thankful for today. Thank you for asking. Is it Segma? Hello, I binged, watched all your videos. Thank you so much. Abel, greetings from El Paso, greetings from Dallas. Back to you, Abel. Thank you all so much. I hope you all can see my shirt. It's another one of the Judge Vonderby sayings. I'm not about to play with you. Okay. So we're going to go ahead and jump on in. So Tuesday, we talked about the temporary orders hearing. That was part one. That was like the introduction, telling you all what a temporary orders hearing is, what it consists of, the financial documents you need, what type of witnesses you need, and everything like that. Today, I got a lot of feedback from you all. So I want to talk about some of the things that can happen in a temporary orders hearing regarding temporary injunctions, ex parte orders, and temporary restraining orders / protective orders, right? So when you think about an injunction and you think about the word temporary, that is something that the court wants and orders you to refrain from doing on a temporary basis until we get to a point to where this is going to be a final situation, right? So that's where we're at on this. In the temporary orders hearing, judges usually, these are the things that judges can play at the time that you have your temporary order. So when we talk about temporary injunctions, remember, I'm always going to give you all the code section because I want you to know that you can go back and read up on this information on your own. This information is informational purposes only applicable to Texas law. If you're watching and tuning in from other jurisdictions and you have specific questions about something I may say, I may not be able to answer it, but I may be able to get you to an attorney within your jurisdiction, or you may have to consult and find your own attorney within your jurisdiction. Okay. So for temporary injunctions, we're looking at section 105.001 of the Texas Family Code. So what are injunctions, right? That is where the court is refraining one or both parties from performing certain acts. There are certain things that I do not want you to do. There are certain things I do want you to do. That is what the court is essentially saying. And for those of you who've tuned in for the first time today, when you hear me say court, that is synonymous with judge. So if you hear me say judge, court means the same thing. Okay, we're not talking about different people here. So, what are some examples of injunctions. Some examples can be the court telling you not to discuss the pending litigation with the child. The court can also instruct you not to discuss the pending litigation in the presence of the child or within the hearing of the child. So if the child is in an adjacent room, it may not be a good idea for you to be discussing the litigation, because why? There's a likelihood that they may hear what you're saying, right? So definitely no discussing the litigation within the presence of the child or children or within the hearing of the child or children. Hiding or secreting the child. So you're removing the child not only from school, you're removing them from the current residence they're at, you're removing them from the state or even the country. Those are some of the type of things that the courts are talking about that you refrain from doing. Diminishing joint accounts. So for those of you who may be representing yourself in a divorce, the court can order you to not make certain expenditures if there is a joint account that is shared between you and your spouse. Removing a large sum of money or even small amounts of money in a short period of time from your retirement accounts, from your 401k accounts. Why does that matter, Vonda? It's my 401k. It's my retirement account. The money that I put into that joint account is my paycheck. Why is that? Because only half of what is deposited into that 401k account, that retirement account, or that joint account, only half of it belongs to you. Because why? We're in Texas. Texas is a community property state. So half of that income belongs to your spouse. So the courts do not want one or both spouses to be diminishing the community property estate, right? So those are some examples of temporary injunctions. Judges typically issue those at the temporary orders hearings. Some other injunctions that may come up depending on your case. So if your case involves drug usage, I know smoking weed and all of that, marijuana is legal in some states. Here in Texas, it's still illegal. So the courts can put an injunction that you are refrained from using any type of illegal substance, including marijuana, right? So you live in Texas, you have a possession and access schedule out of Texas with your child. You go to Colorado for the weekend. Marijuana usage is legal in Colorado. If I come back to Texas and I have to do a drug test for the temporary orders hearing and I test positive, can I be restricted from seeing my child? I'll let you all answer that question. So again, let me give you the scenario again. I live in Texas. I go to Colorado for the weekend. I use marijuana. The other party requests that I take a drug test for the temporary orders hearing. If I test positive for marijuana, could I be restricted from seeing my child? So I want you all to contemplate on that and let me know in the comments if you think that person may or may not be restricted from seeing their child. And just a reminder to you all, the super chat feature should be available. So if you want to ensure that I see your comment, it will be highlighted. You may want to participate in our super chat feature. Just an idea to throw that out there. Okay. The next thing we're going to talk about are what's known as ex parte orders. X, second word, parte, Parte, orders. Now, one of my really good friends, she lives in LA and she practices law in LA County, and they refer to it as ex parte. It means the same thing, right? So what is an ex parte temporary restraining order or an ex parte protective order in Texas? Well, let me say this. Before we can even address what those orders are, let me first walk you through what you have to do. Make sure you have your pen and paper ready, because I'm assuring you, if some of you that are out there dealing with this situation, or you know someone with this situation, this is extremely valuable. Because if someone walks into my office today and they needed to file an ex parte protective order, they're at least going to pay me $10,000 for filing it and defending it in court. So this is $10,000 worth the information. Okay. So make sure you all are following me. Before we can even talk about, I need a protective order, I need a temporary restraining order, you walk in my office, Vonda, this is the situation, I want this. Well, before we can even talk about filing an order per se, or getting an order, we have to first make sure that your facts meet the requirement for those types of orders. Okay. So when you say you want something ex parte, that means that you do not require much notice to the other side. Most lawsuits, if anybody has ever been served with a lawsuit in Texas, it's 20 days that you have to respond, right? It's not like that with an ex parte suit or an ex parte request. The person that's filing it only has to give you, the responding party, 2 hours notice. And that's in most local rules in courts throughout Texas. 2 hours. So just imagine you're sitting there and you're at brunch or you're at breakfast or something, and it's 11 o'clock in the morning, and you get a notice, a text message, something in writing saying, I'm presenting this to the judge at 1 o'clock p.m. in this court. That's notice for an ex parte. It's essentially saying that there is an emergency reason that I need to be in court and I need to request this type of relief, because if the court does not do something right now, this child or myself, we are going to suffer irreparable harm. The harm will not stop unless the court intervenes and does something. That's what you're telling the court on an ex parte. This is an emergency, judge. Down 911, right? This is an emergency. So that's what you're saying. When you make this request, you have to file an application. These documents, if you're in Texas, they're available online. You can Google Texas Law Help. I think it's .org or something like that. Google it, find the document. The document must consist of your name, the last 3 digits of your driver's license, the last 3 digits of your social. It tells your standing. Standing is what gives you the legal right to be filing a specific or a particular lawsuit in a court. That's what standing is. So you're either the biological mother, you're the biological father, you are the maternal grandparent who has been in possession of the child, you are the paternal aunt or uncle that has been in possession of the child. Whatever your relationship is, that's your opportunity to tell the court, right? This is all a part of the application. The most important part of the application, though, make sure you all write this down. You have to file and attach to the application an affidavit stating facts that are clear and that are presently happening, right, to yourself or to the child, that is causing irreparable harm, and there is a clear and present danger going on right now that if the court does not intervene, the situation is going to get worse. Okay? I hope you all follow me on that. When you're talking about ex parte orders, we're talking about section 82.009 of the Texas Family Code, as well as section 83.001 of the Texas Family Code. Remember, you must have an affidavit attached. And I'm going to break these down by bullets because I want to make sure that you all get this information. Remember, I told you this is $10,000 worth of information that I'm giving you all right now. Okay. Application. You must have an affidavit attached. Okay. Affidavit must allege facts that are within your knowledge. Vonda, what do you mean by that? So the neighbor across the street told me that they saw this going on. So I want to ask the court for a protective order. Is that within your knowledge? No, it's not. It has to be facts within your knowledge, meaning that you witnessed it, you saw it, you were told by the other party that this was going on, and you need the court to intervene right now. Clear and present facts within your knowledge in the affidavit. An affidavit is what's known as a verified pleading. Okay. Verified pleading means that that affidavit must be notarized by a notary, an independent party. You cannot notarize a verified pleading on your own, even if you are a notary. It is not good. It will not fly in court. You need to make sure a notary notarizes this document for you. Okay, that's bullet point number 1. Bullet point number 2. You must know that after you file this application and you have your affidavit attached, you've given 2 hours notice. Remember, 2 hours, guys, 48. Yeah, 2 hours notice to the other side that you're going to be presenting it to the court. Okay. This hearing shall, no exceptions, take place within 14 days. Okay. From the moment that judge agrees that, you know what, your situation arises to the effect that needs a temporary restraining order or a protective order, the clerk enters it. The hearing must take place in 14 days. That's bullet point number 2. Bullet point number 3. The actual order itself does not exceed 20 days. Why is that important? Because some people, let's say hypothetically, the court cannot get you in that 14 days. They can't get you in until the 23rd day. If you wait until the 23rd day, what do you think is going to happen to your order? It's going to expire. It's going to expire. So to keep that from happening, you have to go back to the court and ask for an extension on your order. Okay? So remember, the hearing must take place within 14 days. Your order itself does not exceed 20 days because the assumption is that the hearing is going to take place in 14 days. Okay? The next point I want to make sure that you all understand, there is a difference between a temporary restraining order and a temporary protective order. Even if it's not temporary, a restraining order, protective order, completely different things. Vonda, what's the difference? When you're talking about a restraining order, the word temporary is in the very definition of the word. We call it here in Texas TRO. That's the short abbreviation for it. Temporary restraining order is to temporarily stop someone or some business from doing something that is causing irreparable harm. It is causing harm. Unless the court intervenes, it will not stop. Okay? It's temporary. It's nothing that is final. Okay? When you talk about a protective order, they do have temporary protective orders, which I told you, you can get that on an ex parte basis. The difference is, though, if the court finds that family violence has occurred within the 2-year period preceding that suit. So what do I mean by that? You have an original suit you're going in court for. This is an original divorce, an original suit involving children. Family violence has occurred 2 years preceding that, and you want to get a temporary protective order entered. The courts may, after listening to your testimony and the evidence that you present, may go ahead and enter a protective order, a temporary protective order. And that's all it is. It's temporary until finalized. The difference is the protective order, if it is found that family violence is likely to occur in the future, the court can enter a protective order for the next 2 years. The court can even enter one for an indefinite period of time, just depending on how bad the situation is, right? So the person that gets a temporary, not a temporary, protective order put in place has the option to petition the court and ask them to go beyond the 2 years. And they also can ask that when the 2 years expire, they can go back and extend it beyond that 2 years. You just have to keep going back those 2 years, right? So the difference is that a temporary restraining order is just what it says. It's temporary, right? Another difference is that if you were to call the police, and this happens a lot in Texas. Now, granted, this depends on your police department, who the police officer is that showed up. There are a lot of different factors. But generally speaking, a temporary restraining order doesn't necessarily get the police at your front door. A protective order does. Why is that? Because usually in a protective order, it has language in it that says you cannot be within a certain amount of feet of this person's residence. It lists out the residence address if it's a situation where it can be disclosed, and I'll talk about that in just a minute. It also says that this person's work address, you got to stay so many feet away from it. The child or children's school, you have to stay so many feet away from it. It is very specific. So if you were to call the police, if you have a protective order in place, it says that the other person cannot be within 50 feet of your residence. And you look outside your window like I'm looking out right now, and you see that person 10 feet away from your window, and you call the police, and that person is there, guess what's going to happen to them? They are going to go to jail. Okay? Temporary restraining order? Not necessarily. Okay? Some cops may ask the person to leave, or they may ask the person to follow their court order, or give them a trespassing ticket. A protective order, you have far more protections with a protective order. It's serious. And I don't want you to think that the temporary restraining order isn't serious. They're both serious, because violating it could result in fines, right? Where you have civil contempt, you're ordered to pay a certain amount of money. Protective orders are slightly different, because when they are issued, they go to the local police department. It has the person's name, address, social security number, eye color, hair color, height, weight, where they work, phone number. It pretty much has everything related to that person on a protective order. So it's understood that this person cannot come within so many feet, or they're dangerous. They need to stay away from this person. So I hope I cleared that up for you all in regards to the difference between the protective order, the temporary restraining order, temporary injunctions. And I don't think I said this, but temporary injunctions, they can become final once you get to that final stage. It just really depends on what happens in your case. Okay. Now, when we talk about what needs to be in an order, remember, me giving you this information is assuming you are doing this on your own. After you do the application, you state the proving clear and present issues of family violence, whatever the case may be at that time. After you do that, you have to send a final order. A final order asking, or where the court has found what you're asking for. There has to be certain language in there. If it is based on family violence, you have to have a clause in there that states what the relationship was between the applicant, the person who applied for the protective order and or temporary restraining order, and the respondent, the person who allegedly did, the I guess you could say crime, but crime is not really a good word because we're in family law, right? We're talking mostly about civil, but the person who committed whatever offense we're referring to, right? So it has to state the relationship. Is it a dating relationship? Are these people still married? Were they roommates? Did they ever live together? That is important. Why is that important? Because if these parties are married, we got to take it a step further in that protective order, don't we? We need this person kicked out the house. Texas Family Code allows that to happen, but you have to present certain facts in your affidavit, which is your evidence, right? And you also have to have it in your order, what's called kick out language. Very, very important, guys. You have to have the language in there that provides that this person has to get out of this residence, vacate at a certain date, at a certain time, and you want to make sure that you have the police officer, constable, whomever, actually there to make sure that it takes place, okay? So language is very important in your orders. Information in your that has to be in the protective order in order for the courts to be able to kick somebody out event that we're talking about a kick out order. But again, I'll let you all do the research on that. If you go to 82.009 and 83.001 of the Texas Family Code, and you just keep reading, you will actually find the contents of those orders. Okay. So I just want to make sure that you all are up to date and understand that. I'm trying to think. That's all I have for my notes in terms of what I wanted to tell you all today. I do want to say stay tuned for next week because I want to make sure that you all understand that coming in court saying I want full custody of my child, or I want to be named the person that the child gets to stay with primarily, or make educational decisions for the child. That's not an easy situation. I want to make sure that when you go in this courtroom, you know the exact facts and the exact information that the court needs to see in order to rule in your favor. So next time we're going to dig a little deeper on that. If you want sole custody, or you want to be the parent that is able to determine the primary residence, these are the certain things that you need to be able to show before you go into court. So I will be giving you all that next week. We have reached almost our 30-minute mark. So we have reached our 30-minute mark. So I will start entertaining questions. So for those of you who are joining, we were talking about temporary injunctions at the beginning. And I gave a scenario and I said the person lives in Texas. They went to Colorado for the weekend, used marijuana. The other side said they wanted that person to take a drug test for the upcoming temporary orders hearing. If they test positive, would they be restricted from seeing their child or not? Considering that marijuana is still illegal in Texas, but it is legal in Colorado. So let's see what you all said. Meow Away Wolf said, I believe that may be restricted to seeing her child. Okay. Kendria Dudley, yes, they will. Okay. Okay. So that is the right response, in my opinion. They will more than likely be restricted. Why? marijuana usage is legal in Colorado. I use it in Colorado. Yeah, you use it in Colorado, but your court order is out of Texas. It's still legal. It's still illegal under Texas law. So if you were to go to Colorado, come back, you test positive for marijuana, there is a likelihood the court can restrict your visits. Now, I'm an attorney, so I can pretty much say this because I've practiced in front of Texas judges. Will they more than likely cut you off altogether from seeing your kid for marijuana usage? No. Could they restrict it? Absolutely. But will you be on supervised visits? Probably not. I had a judge in Tarrant County tell me to my face. I said, Judge, mom uses marijuana on a regular basis. He looked me right in my face. He said, Miss Bailey, it's only marijuana. I said, oh, although it's illegal. He said, Miss Bailey, it's not methamphetamines. It's not crack cocaine. It's not some of these harder drugs that people could be taking. It's only marijuana. She just needs to stop using it. Say less. I definitely understand what you were saying. So the reality of it is, depending on what judge you may be in front of, some may not take it as, I'm not going to say serious, some may not handle it as aggressively as others do. But just know that you still could have your rights restricted. So thank you all for participating in that. How can you prove to the judge that the other parent is talking bad about the other parent when it's placed in the order? Fire flame. Thank you so much for asking this question. The way that you can do it, if the safest way to do it, to get that child's testimony into court, because remember, if it's an outside statement said by somebody else that's not present in the courtroom, it's hearsay, right? The best way to get that child's statement in is if that child is in counseling. If that child is in counseling, seeing a therapist or anything like that, and they disclose this, you need to make sure that counselor or that therapist is present at your temporary orders hearing to elicit that testimony on behalf of that child. That's the cleanest and safest way to do it. SKG, you said 10 grand. Yes. When you ask an attorney for an ex parte type situation, we literally stop what we're doing, have to file all of that information, send notice to the other side, probably have to run to the courtroom in person and present the application and the affidavit. So yes, it does require us to cut off what we're doing right then to take care of that issue because it's an emergency, remember? So yes, I'm saying 10 grand because that's what it would be for me. Some of the bigger firms may charge 15, may charge 25, just depending on the circumstances and what they want to charge at that point and how much the person is willing to pay. So absolutely 10,000. Thank you, Ashley, for encouraging people to hit the like button. Yes, definitely hit the like button. Share this. I think it is valuable information to other people. The Janitor of Plymouth, I love watching your channel. I wish we had judges like you in the UK. Thank you so much. Again, I'm not an actual judge in a courtroom, not yet. I'm currently running for judge. I'm a family law attorney. I practice family law exclusively. That is literally all I do. So child support, child custody, divorce, adoption, property issues, name change of a child, name change of adult, all of what I just named, that is what I handle. But yet and still, I still appreciate the compliment. Yes, Ashley, protective orders do provide more restraints. I absolutely agree with you. Thank you, D2 Saucy. They said I was so pretty. I appreciate that. Yes, thank you for identifying the difference between temporary restraining orders and protective orders. You are very welcome. After the child is 18 and is still back child support, who will that money go to? Yes, this is an excellent question. The money goes back to the obligee of the child support. So whomever was the person in the underlying order that was to receive child support for the benefit of the child, that's who the money goes to. Now, that person can be mom and dad. They can choose to hold on to it. They can choose to give it to their child if their child is over the age of 18. But ultimately, if they choose not to give the money to the child, they really don't have to. They're the obligee under the in the underlying order. Come to Pennsylvania and put some order. That is funny. Thanks, Vonda B. Vonda B, you are the real MVP. Great information, Vonda. Thank you so much. I appreciate it. Kick out language. Keywords are important to getting the assistance and results you desire. Thank you, Judge. You are very welcome. Meow Away Wolf. Non-custodial is unemployed since September of 21. Okay, that's fairly recent. With back pay, child support. Please advise what can be done for the custodial to receive payments. P.S. The Attorney Generals seem not to be on top of it either. Okay, so let me just say this. The Attorney General's Office of Texas, a day when we were in person, they were handling between 500 and 1,500 cases a day. And they were in the courtroom Monday through Thursday. Friday is their office day where they're playing catch up, essentially, because they're in court every day. So the short answer is, if it's only been since September of 2021, that's fairly recent, fairly new. They're not in back pay to where it's extremely delinquent, where they owe like $50,000, $100,000. So that's probably why the Attorney General is not acting, maybe as swiftly as you may like, because that case is still recent. I would say give it another month or two, a little bit more time, then file a contempt action and ask that they are pursued. I will go into contempt action so you will know exactly what to do on those, okay? Child support said they are intervening in our child custody. What does that mean for me as the person who filed? What do I need to do? Okay, that is a great question. If they are intervening in the custody, that means that they have an interest in the child support. 9 times out of 10, when I've seen that happen, the child is receiving Medicaid. You all have seen this repeatedly in my cases that I'm reenacting. Medicaid is a government assistance program. It's not health insurance in the means of through an employer or anything like that. It's a state governmental assistance program, meaning it has to be paid back. The state want their money and they want somebody to pay it. 9 times out of 10, it's going to be the non-custodial parent. Okay. So what I would do, what I would recommend doing if I were in that situation, is to try to see what the exact reason is that they're intervening. And if it does have to do with medical support, see about enrolling that child on private health insurance. Okay. Thank you, Ashley. The audacity of the judge, illegal is illegal. Love you, Queen. Thank you. The child is between 3 and 5 and was telling a story that the non-custodial parent could not stand the other parent. She told the story while playing with her dolls. Now, Fireflame, that's an excellent point, because something else I want you all to remember too. Coaching is very real. And let me take a sip of my tea on that one. Coaching is very real. What do I mean by coaching? Not saying that it happened in your situation, but I see it happen very frequently where parents coach their children on what to say about the other parent. Okay. I've seen coaching in some of the worst cases of parental alienation, to where that child knew exactly what to say when a certain look was given. It was very, very disturbing. Okay. So, independent counselors usually get on that case that the court appoints to interview the child. So they're able to not necessarily test the veracity, the truth about what the child is saying, but to see if that child has been coached in any way. I love you too, Ashley. Precious, you're very welcome. SH, you're very welcome. SKG, is it a crime to falsify a protective order or restraining order? It absolutely is. Now, if you're asking me, does it happen often? No, it does not. And in my opinion, it should. Because if it happened a little bit more often when people run into the courthouse filing these false claims that they would get in trouble, you would see a decrease on people doing it. But because there's really not a whole lot on repercussions that happens, you see an influx on people doing it all the time. It is it's extremely annoying because it backs up cases that actually have legitimate reasons to be in court, right? So I definitely think it needs to happen more often. Thank you for answering. I look forward to the contempt action to file accordingly. You're very welcome. My mom coached the hell out of me as a child. Lisa, I can definitely believe it. I have seen it happen. Have I seen men do it that are in possession of the children or the custodial parent of the child? Absolutely. But I have to say, my ladies, we are notorious for doing it more than the men. And when it comes to males in particular, raising males, based on my experience, is more detrimental when the mother does it and a young boy is involved. It's the most heartbreaking thing I've ever seen. It's heartbreaking when I see it happen, whether it's a male or a female child, but it's definitely more heartbreaking when I see it happen when it's a male child, because men already have a hard time expressing feelings, right? Men typically are non-confrontational. They just like to say, you know what, let's move on from here and go on with that. So when you think about a child who's been emotionally and psychologically damaged because the mother has planted negative things about the father in their head, that is the most unstable situation I have ever seen, because that child turns out to be very, very emotional to where the feelings cannot even be controlled. And it's sad. I've seen it happen with, like I said, with females, but females, because we are already emotional, we can kind of work through that a little bit more. But with the guys, I have not seen it without some sort of intervention, like counseling or something like that. So I can say it has been extremely detrimental in my experience, more on the male child than the female child. I have been alienated from my 1 year old for 114 days. Oh my gosh. He refuses to give me my child back. I've attempted to pop up, but I feel that's not a good idea. We have domestic violence. Should I file the ex parte? Well, thank you for your question. And I'm extremely sorry that you have not seen your child in that length of time. I'm praying for your situation. That's all I can say. That is extremely saddening to hear. An ex parte situation is probably not best for your situation, because you have to prove that your child is going through or suffering irreparable harm. And it has to be, remember, clear and present circumstances at the time that you file the application. So I don't think an ex parte situation is appropriate in your case. However, if you do not have a court order, I highly recommend you run to the courthouse and file an original suit so you can get one. This is assuming you are in Texas. And if you already have an existing order, you need to ask that it's modified. So much great information. In Texas, how often does the father get full custody over the mother when he has a better living situation? SKG, this is a great question. It really depends, right? Because it's not just a better living situation. Let's break that down. When we say living situation, it's not going to be enough that you may have a degree and mom has a GED. Or she may not have a GED. She stopped literally in middle school, going to school. That doesn't mean you're better suited as the parent over her. It's a lot more that goes into it. Now, let's dig a little deeper. You can provide a roof over this child's head. Mom cannot. Within a year, this child has changed 7 schools. because mom does not have suitable living and she pretty much bounces around place to place. The child is around people in different environments. They use drugs. Sexual abuse has been committed, those type of things. Can you get full custody over a mom in that situation? Yes. I will say, though, you don't really see a lot of you see more of it now. But when I first started practicing law, you didn't see a lot of fathers filing suits to take custody because in their mind, they thought that they were being ugly to the mom or whatever the case may be. But you do see a lot of it more now. So in Texas, based on my observation, there are a ton of fathers getting custody over the mother with these children. Can family law attorneys help with living wills, or what needs to be filed if custodial parent passes? Now, this is a great question. Living wills can be performed by any attorney who knows how to do them. Usually when you see wills, you're talking about a probate attorney. That's someone who specializes specifically in estate planning. So a living will, what's going to happen to your estate once you pass away? Do you need a power of attorney? If something goes wrong with you, do you want the plug to be pulled, or do you want them to resuscitate under a medical power of attorney? Those type of things are performed through a probate attorney. So that's who would typically file it. Time frame is what I mean when I said limit. Now, it's against public policy to put anything in a will concerning the child if one parent, the custodial parent, passes away. That's against public policy. Now, can you put it in a will what your wishes are? All day long. But it's against public policy because if another parent is living and there's no order in place, there's a presumption that the other is best, it's in the best interest of the child that the other parent has the child, right? Let me see. Once the child turns 18, can the child sue for back child support? Precious loves, yes, the child can. The child has an interest because they are the recipient of the child support. They can definitely file or sue to recoup the back pay. Let's see. Yes, thank you. Meow Away Wolf. Precious Love, they have a legitimate point. I would encourage you to go back and look at the episode from Tuesday. I did discuss this particular point. Let's see. And Precious Loves, if I am not clearly answering what exactly it is you're asking, please put it in the chat again. John Spencer, ma'am, you are awesome. Thank you for the information you provide. Thank you so much. I appreciate that. I'm just doing my best to perform what is expected of me from my mission. I don't know how many people are here are religious, but like I stated from the beginning, I'm a Christian. So I believe this is part of what my duty is, to give you all this information. Lisa, in Illinois, the fathers have to pay back food stamps. Does dad pay the whole amount or half? Will paying it lower child support? My boyfriend X just told us she gets link and he has to pay it back. Well, I know I'm not licensed in Illinois, but I do know in Texas, to answer the first part of your question, if someone is receiving food stamps, does dad have to pay it back? They do have to pay back the whole amount. It's not half, it's whole. Will paying it back lower child support? In Texas, it absolutely will not. If you have a question specifically concerning that about Illinois law, I believe I have an attorney out in Illinois. I'm not sure which county or anything they're in out in Illinois, but I can definitely put you through with an attorney that's in Illinois that may be able to answer that question better for you. What happens when the mother was a custodial parent, but she decided to give the kids to the father? Okay. He files to get custody, but the court in Texas did a temporary custody order. That's standard. So when you file for custody, usually this is what this whole series is about, the temporary orders hearing, which is what you're referring to with the temporary custody order. That normally is what comes out of a temporary hearing. It's a temporary order that is issued, that is a band-aid, and tells what the rights and duties and obligations are of each parent. So dad, I hope that and let me see what you say. Why the judge didn't give him custody then? Well, it really depends on what happens, because a lot of time, and I'm not saying you're being dishonest, but I've been an attorney for a while now. So sometimes when you're on here talking, you don't necessarily give all the facts, all the background facts, because something that seems very minute, very small, could be the trigger that turns everything on its head as to why he didn't get custody. So there could be a number of reasons why he didn't get custody. What right does the child have to sue for child support, back child support? The mother or father took care of the child even when child support wasn't coming. That is a good point. But they are a recipient. So anytime you're a recipient, you can look at that person as a third party beneficiary, right? So let's talk about life insurance, Detour just slightly. The person paying into the policy is the person that you would think should receive the benefit of the policy. But usually there is a third party beneficiary that when the insurance policy pays out, that is going to go to. Is it right to say that they shouldn't get it when this person designated them, or they're the person who has an interest in it? So it works the same way with child support. It's for the benefit of the child. The child is the beneficiary, so it should go to the child, which means that they should have a right to sue as well. Vonda, could you elaborate more on the food stamps? The non-custodial pays the whole amount. Is this supposed to be filed through the court? So when you say food stamps, you're talking about governmental assistance. Here in Texas, it's called SNAP, Supplemental Nutrition Assistance Program. That's food stamps in Texas. So whenever a parent applies for Medicaid, that's the governmental assistance for health related things for the child, right? It automatically opens the door for you to have all those other governmental assistance benefits. So beyond Medicaid, you have SNAP, like I mentioned, which is also food stamps. You have CHIP. You have CCMS, which is the daycare assistance program that normally gives parents the right to pay less or get free daycare services. You also have TANF, which is temporary assistance for needy families. So you can get some sort of assistance with your electricity bill, your phone bill, all that kind of stuff. CHIP, I can't remember what it stands for right off the top of my head, but it is another governmental assistance program here in Texas. Whenever you apply for any of those, it triggers the what you say food stamp option, right? In terms of the non-custodial parent paying it back. So whatever has been given in a Medicaid benefit, the non-custodial parent has to pay it back to the state, which is Medicaid. They have to pay the whole thing back. It's not a break or anything like that. You got to pay the whole thing back. Fireflame, how can you prove to the court that the custodial parent is making it difficult to see the child? They're given the days that the court ordered, but every day I'm not exactly clarify that ending part for me. I want to make sure that I answer according to what you're asking, Fireflame. The mother didn't show for court. Maybe that's why. That could be why. See, it's always a back reason why some things didn't happen. If mother didn't show up, so the court has two options. They can either enter a default or they can do a reset. It really depends on the judge and the facts that are going on in that particular case. If a man puts his name on the child's birth certificate, but he does a DNA test to prove he is not the biological father, is he still responsible for child support? Depending on the situation, more than likely, he's not. Putting your name on a birth certificate, Mickey Mouse. You can put Mickey Mouse as the child's father and Minnie Mouse as the child's mother on a birth certificate. Are you going to call Disney and say, you owe me money? Nah, it don't work like that. You can put anybody's name on their birth certificate you want to. That is not a legal document that's not a document that makes you legally responsible for the child, for child support. It can be used to show that you knew there was a possibility you could be the parent, but that does not make you legally responsible. What makes you legally responsible in terms of child support and in terms of being the responsible person for this child, period, is signing an AOP, an acknowledgement of paternity. That's usually signed at the hospital in Texas courts. Do not sign that without a DNA test, okay? Do not do that. And we will go into, more importantly, why you don't want to do that. I'm going to break all of that down for you once we get into our series about child support, okay? You're very welcome, precious love. If the custodial parent is on assistance, can you get custody? Absolutely. Just because they're on assistance doesn't mean you can't get custody. Now, if you get custody and that other parent is on assistance, all that would happen is that the assistance benefit would then come to you instead of going to that other parent. But you got to let the court know that's how the situation is. Obviously, they're going to keep it like it is where the other parent is the beneficiary. Are both parents required to be listed on the birth certificate, specifically the father? The answer is no. It's not a requirement that the father is listed on the birth certificate. Remember, you can put Minnie Mouse, Mickey Mouse, Jay-Z, Beyonce. You can put whoever you want on their birth certificate. It's a birth certificate. It's pretty much showing proof of birth. This child was born. This was the time. This was the date. This is the mother of the child. This is their name, and this is the location that it took place. Nothing more, nothing less. It's just a record of birth. What happens if a parent doesn't show up for a custody hearing? Oh, okay. You got your answer, Jamaica? Okay, great. The court order days are granted, but the custodial parent make them drive all around town to pick up the child and change locations. Fire flame, do not do that. If you want to ever have the chance to hold that other parent in contempt in Texas, you have to follow the court order according to its terms, unless there is an agreement to go away from those terms. Okay, so if y'all agree to an alternate day or an alternate exchange location, that's different. But you can't just say yeah and roll over. You show up to that place you're supposed to be at the time you're supposed to be there, ask for a police report, and you try to then later file a contempt action to get that person held in contempt. We'll go into enforcement though at a later date. So can the father be removed from the birth certificate? Absolutely. Now, can he force it to be done? No. But can a court order that mom remove this parent who is not the biological parent from a birth certificate? Absolutely, by court order. Say that non-custodial parent is in another state. Then the child, which state do you file, and what does that change if you move again? You file in the state where the child resides. You file in the state where the child resides. Whether you move or not again is not the issue. You file in the state where the child resides. Let's see. The police refuse to give a report. It's not easy to get a report from a police officer. I agree with you. It's not easy sometimes, but you literally have to demand it. Even if they don't necessarily come out and give you a report, you have to still insist that they give you something, some sort of incident report in writing. Okay, we've reached our 3 o'clock mark. Jamaica Butler, if you would do me a favor, you said you didn't get the answer. You were saying thank you for the other. Can you send me an email? And this is for anybody questions related to Texas law or anything that I just discussed related to Texas law, and I wasn't able to clear it up in your comments. Send me an email at judgevonderb@gmail.com, and I'll try my best to get back to you. So that includes today's live session. Next session, this is extremely important because a lot of you in the comments are asking about custody. I want you to get custody of your kids if you have the facts to support why they should be in your custody full time. So I'm going to break down to you what judges want to hear when you go in these courts asking for full custody, or what judges want to hear when you go in these courts asking that you're named the primary parent. I'm going to break all that down for you. Rest assured, we will be back here on next week. What day is that? I got to pull my calendar up. Give me 1 second here. Next Tuesday, to be exact. Let me see. What's today's date? Today is the 11th. So next Tuesday is the 16th. On November the 16th, 12 o'clock p.m. Central Standard Time. Okay. November 16th, 12 o'clock p.m. Central Standard Time. We're going to go through all of this. I told you I do not make promises I can't keep. So we will go from the start of a custody case with an original or a modification, and I'm going to take you all the way through the end. You will get all the information you need. Thank you all for tuning in. Have a good weekend. Happy Veterans Day to any of my veterans out there. Thank you so much for your service. You are the part of the reason why America is great. Thank you. Talk to you next week.